Rockets and Knicks were in Game 5 when O.J. started that fateful drive. His four-way hazard lights were blinking, and no one knew what the juice was thinking.
I've been to Reno, Chicago, Fargo, Minnesota, Buffalo, Toronto, Winslow, Sarasota, Wichita, Tulsa, Ottawa, Oklahoma, Tampa, Panama, Mattawa, La Paloma, Bangor, Baltimore, Salvador, Amarillo, Tocopilla, Barranquilla, and Padilla. I'm a killer. I've been everywhere, man. I've been everywhere, man. Across the desert bare, man. I breathe the mountain air, man. I've traveled, I've had my share, man. I've been everywhere.
This is Oversight Live, your advocate for good governance. We're putting the site back in. Oversight. Here's the watcher on the wall, your host, Ben Carpenter.
Hey, good evening, everyone. Let's turn that down so you can not get squealed at. Good evening. Good Tuesday evening, the 17th of March. Thanks for joining us tonight. What's Oversight Live, you might ask? Well, Oversight Live is new, and it's an effort to help educate Alaskans. Our Alaskan state capital and legislature is only accessible by plane and by ferry. We don't have a road to our capital. So it is prohibitively expensive in both time and money for most Alaskans to go visit our legislature, visit our center of government. Providing oversight of our elected representatives and our government is a greater challenge for Alaskans than it is most Americans. Oversight Live is your road to Juneau until we can build one. It's a major inconvenience to not have a road and to have such great cost to get to our government, but it's not a valid excuse anymore for not knowing what's going on. We're going to bring you convenient and relevant content so that you can be informed and educated with the actual truth without traveling to Juneau or having to filter through the liberal media bias. You will have my bias. I am unabashedly a limited government, fiscal, and social conservative. So I'm going to be right up front with that. You have the opportunity to engage with your host, yours truly, and with other Alaskans to seek answers to your questions or just to be connected with like-minded individuals in real time as the show progresses. If you've got a question, enter it into your chat window there, and it's going to pop up on my window, and I'll do my best to answer the questions, live. If you're watching the recording, then send me an email, producer@oversightlive.com, and I'll do my best to answer that question. Look, if you've got good questions, it's likely that other people will have a similar question. So don't be surprised if I use that question online live or come back to a episode and answer a question that was asked by email. But we need to edify everyone. And if you've got a good question, it's probably been asked, probably in somebody else's mind as well. So I served in the legislature, in the Alaska State Legislature for 6 years. 4 of those years were as minority member. 2 of those years were as a majority member. I chaired the House Ways and Means Committee, and I chaired the Legislative Budget and Audit Committee. My 4 years as the minority I served as a finance member on the House Finance Committee. So a lot of my focus and my experience is heavily in the finance arena, budget arena. I'm going to do my best to impart my knowledge that I learned in that 6 years with you so that, my experiences don't go to waste. We're going to try to have fun doing this. I'm going to do my best. All right. I'm a pretty serious guy, but some of this, we're going to try to keep a sense of humor at least. All right. We're going to get started tonight, and we have a a serious topic that I had to approach twice today. And since it's on my mind, I'm not going to try to put something else on my mind. We're going to talk about it. And I'm going to help shape the conversation and hopefully edify and increase your understanding and your knowledge about this particular topic. Now, what is it that I'm talking about? Well, this morning I was, I spend 2 hours every Tuesday morning co-hosting the Sound Off program on KSRM down here in Kenai with Dwayne Bannock. And this morning we had a conversation about grand juries. And it was a pretty lively conversation between he and I. Both of us got a little different perspective on grand juries. And then what kind of set this off is we were having we were informing the public that there was going to be a public testimony opportunity in the legislature today in the Senate regarding a bill that's addressing the grand jury. And so I called in to the legislative committee and spoke to the committee, just providing my own feedback during public testimony, and like a number of other Alaskans did. Okay. So that's kind of where my headspace has been for the rest of this day. So why grand jury? Why is this important? Okay. Well, that's the question that we need to ask. I think that there are many Alaskans that don't actually really understand what a grand jury is. If you've never served on one, or you've never been on the receiving end of what happens in a grand jury, then it's probably just one of those government functions that happens behind the scene, and you don't really understand what it's there for or what it's all about. What's the difference between a grand jury and a jury? What we call a petit jury. You know, the kind that you see on movies where there's a trial and the jurors are, wonder, did that guy do it or did he not do it? Right? That's not what I'm talking about with a grand jury. Those are two separate things. You got a petit jury, a jury, a trial jury, and then you've got a grand jury, which serves a completely different purpose. Okay. So why is this important? Yesterday's show, I showed you a couple of video clips of the legislative committee process in action. The one that I want to highlight here and tie into the conversation we're having is the one from Senate Finance. Okay. And I'm not going to go back and show it to you. You can watch the episode from yesterday, but I am going to describe and talk to you about a particular issue, a couple of issues that came up in that committee and how it relates to a grand jury. Okay. So we'll get to that. I think where I want to start the conversation is to frame this from a very basic perspective. Okay. You and I, we live in the state of Alaska. And if you're watching this and you don't live in the state of Alaska, then we live in the United States, and we're neighbors. We're citizens of the same state, citizens of the same country. Okay. We have to figure out a way to get along peacefully, or those things that we would fight over in life, who has access to water and who doesn't, who has access to food, who doesn't. Is this land my land or your land, right? All of those things that we would just normally have to have a conflict over at a very basic level, we got to figure out some way to agree to live peacefully, okay? So this has been done for us. 250 years this nation has been in existence now, okay? We've got a constitution that was written, a federal constitution, and then each one of our states has got a state constitution. And that document and those words that are on that document at a very basic level are spelling out how our governments are going to exist, what rights exist amongst the people, and how power is going to be distributed amongst the people who are agreeing to live together. I recently had a conversation with a friend of mine, and we were talking about family lineage. Okay? Hang with me for a second. Some members of my family have done a lot of genealogy, and they have looked back a number of years and spent a lot of time researching where my family came from. Okay? And my family tree that's written down on paper that we've been able to trace back through the generations goes way back to before the founding of the country. It's well over 250 years of genealogy. How many carpenters are there between now and who first came to America, right? Well, William Carpenter was the first one that arrived. He came over on a ship called the Beavis. I don't know much about him. He came over in the 1630s. That's on, obviously, my dad's side of the family. On my mom's side of the family, I've got a number of, and because it's such a broad tree, there's a lot of family members that are from this time frame. But these are some notables, right? Roger Williams, who founded Providence, Rhode Island, founded the first Baptist church in America. That's from my mother's side of the family. Same time frame, coming over in the 1600s. Bradford, Governor Bradford of Massachusetts, I think it is in my family lineage. Came over in the same time as like a signer of the Mayflower Compact. Okay. The reason that I bring this up is because those individuals all left England at certain stages of their life, and they came to America, and there was no neighbor. The neighbors were on the boat. They got to America, and there were no neighbors. There was no government. There were no cities. There's no infrastructure. There's no nothing. 139 years later, 100 and some years later, we've got the country forming. Okay? The point that I'm trying to make here is that you had people coming from England who were escaping something, or they were just adventurous and wanting to go have an adventure and live a new life, right? But they had their reasons for why they left, and they came to this new country, and there wasn't a university here or a government here to say, hey, these are the experts, and now you're going to have to figure out how to live with each other, and these experts are going to tell you the best way to do it. No. These are people that maybe at best had some training, some education through their university system back in England, or their schooling that schooled them on history. And that's it. I mean, they don't have, it wasn't a let's send over the degreed individuals on the boats and they're going to establish the government for us in early America. That's not what happened. There may have been people that come over that were educated, but it wasn't an organized effort. Okay. So the people who arrived are the people who you had to form a government and figure out how to live with each other. Okay. It's no different than it is today. If we allow our betters, right? I've got a degree and therefore I know what's best. I'm an attorney. I'm a member of the bar and I know what's best. Okay. If we let those people tell us how we have to live, then we're going to live the way they say that we're going to live. We have to know that there's an alternative, or that when they're wrong, right? We have to know that if we're going to push back. Okay. So this is the framework at the very basic level that I'm trying to paint here as we're having a conversation about grand juries. Why is that important? Well, because grand juries go all the way back to English law. It isn't something that we created in the United States or created in Alaska as something new. This is something that goes back all the way to English law. The grand jury, as it's written in our Constitution, is a watchdog for the people. Serves a couple of purposes, and we're going to get into that. So I want to point, I just want to help us see that we have to understand our founding documents and the purposes behind the founding documents. And we have to understand that we're still doing the same thing that the early settlers did in our country, trying to figure out how to work together. And it requires us to have knowledge and understand history and understand the why behind things and to participate. If we don't, then we are going to be subject to those people who do choose to participate. And with regard to the grand jury, we have been being subjected to members of the Bar Association, attorneys, lawyers in the Department of Law and in the judicial branch who have been running this judicial system that we have and controlling the grand jury to the exclusion or to the outside of what the Constitution actually affords them the leeway to do. And now we have to claw that power back. Okay, those are bold statements, and I'm gonna back them up here now. Okay. All right, let me share the screen. We're gonna jump first to the state constitution. As Dwayne Bannock likes to call it, the despicable document. I'm in agreement. I don't like the Constitution. I think there's lots of things that need to be changed in it. Make it bigger here so you can see. All right. So you've got the different makeups of the Constitution here. Article 1 is a Declaration of Rights. Article 2 is where the legislature is spelled out, how it's going to operate, what its powers are. Article 3 is the executive, what the governor and the executive branch powers are. Article 4 is the judiciary. Okay, so those are what's pertinent to this conversation today, all right? Okay, foundationally, inherent rights. Bear with me, okay? This piece of paper with the words written on it is dedicated to the principles that all persons have a natural right to life, liberty, and the pursuit of happiness, and the enjoyment of the rewards of their industry. That all persons are equal and entitled to equal rights, equal opportunities, equal protection under the law. And that all persons having corresponding obligations to the people of the state. Okay. That last piece is something that I'm like, what obligations do you mean? It's not that's part of the despicable nature part of this. Okay. It's not clear. All right. But this is clear. Source of government. All political power is inherent in the people. All government originates with the people, is founded upon their will only, and is instituted solely for the good of the people as a whole. Okay? So that's the source of our government. It isn't the government created the state to exist for the people. The people created the government to exist for our betterment. Okay. Then, through the rest of the Declaration of Rights, you'll recognize the other freedoms and rights that we enjoy, okay? When you think of the grand jury, you think of something that has something to do with court, with law, with prosecutors, people getting charged with crimes. So if you were going to the Constitution to try to find, where does the power of the grand jury come from? Well, you would think that you would go to the Constitution, the section that talks about the judiciary or maybe the executive branch. But that's not the case. The grand jury is spelled out in Article 1. Remember, Article 1 is a Declaration of Rights. Our rights. So your grand jury, the power of the grand jury, from the framers of the state's perspective, is captured here in the Constitution. No person shall be held to answer for a capital crime. Okay? That's a felony. Unless presentment or indictment of a grand jury. Except in cases arising in the armed forces, in time of war, or public danger. Okay? That doesn't apply today. Indictment may be waived by the accused. So if you're the one being accused, you can waive an indictment, and then in that case, the prosecution just proceeds by the information that's available. You don't have to go to a grand jury. The grand jury shall consist of at least 12 citizens. This is key. Okay. Grand jury should consist of at least 12 citizens, a majority of whom, so that's 7, concurring may return an indictment. And what's an indictment? Indictment is the thing that's going to hold someone for a crime. Okay. So either they have committed the crime and they've been arrested, or we suspect that they did the crime and we need to go arrest them. Okay. That's what your indictment is going to do. The power of the grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended. Okay, so there's 2 points here that I want to point out that people really need to understand. We have a right in this state that our government cannot just bring charges against us, felony charges that can deprive us of liberty, meaning you don't get to go home tonight, you're going to jail, deprive you of liberty. Even if it's temporary, they can't do that. They can't do that unless you've committed a crime. You're in the act of committing a crime and they capture you and take you to jail for that crime. And then if they do that, they have to charge you with something. Well, that charging process means they have to go to the grand jury, and the grand jury has to look at the information and say, yeah, you've got somebody in jail. They need to be charged with a felony, and here's the indictment. Or you've committed a crime, but nobody's arrested you yet. Well, you don't get to be arrested just because the trooper says you need to be arrested. You go to a grand jury and you get an indictment. And once the indictment is granted by the grand jury, then the trooper can go arrest you. Okay? So keeping it simple here. Two different ways that indictments are served on people. Okay? You have a right, we all have a right to have the grand jury stand in our place. This is 12 citizens, right? 7 of which get to decide whether we're going to be able to be jailed for a crime. So we have a right to have our neighbors in the process of deciding whether we're going to be indicted. Okay? The second right we have with regard to this is that we have a right to serve on the grand jury. This does not say a grand jury shall consist of at least 12 lawyers, 12 members of the Bar Association. It could. It doesn't say at least 12 legislators or 12 judges, 12 law enforcement. It doesn't say any of that other than there are 12 citizens that make up that grand jury. So you and I have a right to serve on that grand jury, assuming that we are upstanding citizens, right? And the third point that we need to keep in mind is the power of the grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended. You can't suspend the ability for the grand jury to make recommendations any more than you can suspend the grand jury's ability to investigate. What does suspend mean? I'm not asking about the legal term. I'm not asking about any of that. I'm asking from the people that came across on the boats who showed up and there's no law. What does suspend mean to the average American, the average Alaskan? It means can't do it. It means there's an inability to proceed. It means you can't meet. Your right to meet has been suspended. If you look at your freedom of speech, what would it mean if the freedom of speech was suspended? It means you wouldn't be able to have the freedom to say whatever you wanted to say, right? Freedom of religion is suspended. Okay, well that means I can't choose which religion I'm going to be, or I can't participate in church the way I want to, or somebody else is going to decide because I don't have that freedom anymore. Suspended is very easy to understand, isn't it? It means the ability for the grand jury to investigate and make recommendations is always at the grand jury's discretion. They get to decide. It shall never be suspended. This is part and parcel of the problem that we have with the grand juries right now. Okay. All right, still framing the conversation here. Let me jump to what happens when you're a grand jury member. Okay, you get selected, you go in, the court system has the responsibility through the court rules of creating a pool of people for selection, for possible selection for grand jury. Okay, so what happens when those people are selected and they're now one of the 12 members? Okay, this is important. All right, so we're going to jump over to the court rules, and the court rules actually have there. You can actually find these on the court website. I'm going to show that to you really quick. So this is courts.alaska.gov, and you can click on criminal procedure down here at the bottom, and it will take you to the rules that we're going to look at right now. So these are the rules of criminal procedure. And the ones that are pertinent to us is Rule 6, the grand jury. Okay, so now Rule 6, indictment and information. This is the part of the rules that they follow in, and the court creates these own rules. Okay, they're not statutes, they're not laws like the legislature creates. The judicial branch creates court rules to guide how the court system is going to work. Okay, so now remember, the grand jury is not under the constitutional authority. The grand jury is not under the courts. The courts don't control the grand jury per se, but the courts have this obligation to ensure that the grand jury is part of the judicial process. So the courts have put these rules together. Okay, the legislature can override these rules. If the legislature meets and has a bill that changes the verbiage in any of this with the appropriate vote, they can change any of these court rules, and the court doesn't have any say in the matter. They just get changed. Okay. Now you might have a constitutional crisis here if the Supreme Court says, "Oh, well, that's what you've put down is unconstitutional," and now there's a crisis that we would have to figure out. But let's leave that question for another day. It's irrelevant for what I'm trying to say. Rule 6 is the grand jury. Okay, so you can scroll down and understand how the courts are going to proceed with the grand juries. And what I really want to show you, what's pertinent to this from a grand juror's perspective, is this oath of office, oath that you're going to be taking. They're going to administer it to you by the clerk of the Superior Court when you get selected for grand jury duty. So you're going to take an oath. Just like a legislator, just like a police officer, just like a judge, all swear that you're going to do certain things. Okay? This is the oath. It's kind of wordy. We'll break it down here. You and each of you, as members of this grand jury for the state of Alaska, do solemnly swear or affirm that you will diligently inquire and true presentment make of all such matters as shall be given to you for consideration. Okay? That's pretty straightforward. Whatever somebody else gives to you, you're taking an oath to take it seriously. You will diligently inquire and true presentment, I'll offer a true statement or a true decision. Okay? But that is not the end of the sentence. It says that you're going to take an oath to say, or instead of just matters that shall be given to you for consideration, and as a side note, that's by either the judge or the district attorney. And in most cases, maybe all the cases, the grand jury is receiving information from the district attorney, but it could receive directions from the judge. So either of those. But what it says here is that you shall also diligently inquire and true presentment make matters that shall otherwise come to your knowledge in connection with your present service. So this has nothing to do with somebody actually giving you information. It's stuff that comes to your awareness. Maybe it's from your memory. Maybe it's from knowing something. Maybe it's from somebody that comes to the grand jury. It's It's information that comes to you other than the stuff that's been presented to you for consideration. Okay. That you will preserve the secrecy required by law as to all proceedings had before you, that you will present, scroll up to the top here, no one through envy. So you will charge no one through envy, hatred, malice, or leave anyone uncharged, unpresented, because you fear, or you have affection for that person, or you stand to gain, or some reward or hope thereof. Okay, so you're gonna be impartial, but that you will present all things truly and impartially as they shall come to your knowledge, according to the best of your understanding. You're going to serve for a period of time, and whatever information comes to you from whatever direction, you're going to be impartial and do the best that you can to fulfill the responsibilities that you have. What are those responsibilities? Well, some of it's laid out in the court rules, but it all points back to, and should point back to, the Constitution. One responsibility: to decide whether you're going to indict people. The second responsibility is to conduct investigations. What happens with the investigation? Well, if you're investigating and you find somebody needs to be indicted, see responsibility number one. you have to issue an indictment. Or you've got another alternative to communicate. What does the Constitution say? Make recommendations. Okay? So you can make recommendations concerning the public welfare. Well, in our system here, we make recommendations through a report, a letter, information that you present to the public on a particular subject. Okay? Now, the Constitution, if you remember, says that make recommendations shall never be suspended. So here's where we get to the crux of the problem here. Okay, so now we're scrolling through Rule 6, and we're going to get to Rule 6.1. Rule 6.1. Grand jury reports, public welfare of safety. I should say or safety, but it says of safety. So now the court system is going to put sideboards, it's going to put guidance on what the grand jury can and can't do with regard to reports, making recommendations. Okay? Go back to the Constitution. Making recommendations shall never be suspended. Okay? So if you can make a recommendation about 9 out of 10 topics, does that mean your ability to make recommendations is suspended? Well, for 9 topics, no. But for one topic, yes. Does the Constitution allow allows the word I'll use. Does it allow the grand jury to have its ability to issue recommendations suspended for 1 out of 10 items? No. The Constitution's very clear. It says shall never be suspended. So this part of the court rules is trying to curtail or contain what the grand jury can actually investigate. And this goes all the way back to the Sheffield administration, Governor Sheffield's administration, where a grand jury investigated Governor Sheffield for corruption, basically. Okay? In my own understanding and investigation and research, I have come to understand that the grand jury wanted to indict Governor Sheffield, but there wasn't a specific law that they were counseled by the lawyers that they could actually charge him with and indict him on something. Okay? I don't know whether that's true or not. I think it's true based on the information that I've seen. It's irrelevant, at least for most of this conversation, because they didn't indict him. But what they did do was issue a report. And that report had allegations of wrongdoing. Following that Sheffield case, the Supreme Court issued Rule 6.1 to constrain what the grand jury was allowed to investigate. So now we're going to take a look at this. A grand jury is constitutionally authorized to investigate and make reports and recommendations concerning public welfare or safety. So far, that's what the Constitution says. An issue concerns the public welfare or safety and therefore is within the scope of a grand jury's investigative authority when. Okay, now we've just skated out onto thin ice because you've got a majority of the Supreme Court deciding what issue the grand jury can investigate based on their definition of public welfare or safety. No longer can the grand jury be allowed to have a conversation about something that the grand jury wants to have a conversation about if the Supreme Court decides that it doesn't fit their needs. Okay, so now there's been a curtailment of the constitutional authority of the grand jury. Okay, so something has been suspended. Not all of it, but some of it. So when can the grand jury investigate with its authority? Okay, courts have now put their thumb down and said, this is the time when grand juries can actually investigate. You 12 people, you can't make your decision. You can't decide anymore unless it meets this criteria. Okay, the investigation of the issue could further public policy of the state. Okay, so that has something to do with public welfare or safety, right? The outcome of the investigation could reasonably be expected to benefit a large number of people rather than to benefit only an individual or small group of individuals. Interesting. So if you've got, let's say, a judge that's corrupt, and there's only a small number of people that judge has actually been corrupt with, that's something that you can't look at? Or maybe if it's a governor or a legislator or some bureaucrat, some government office, if they've only done something wrong, but it's for a small group of people or maybe just one person, that's not the public welfare. That's not a matter that the grand jury could look into. Okay, so now we've said that it's the size of the public. Remember, all political power is inherent in the people, and the judges, a majority of which, it wasn't unanimous. This was not unanimous. There were 2 judges that said, this is incorrect. This is unconstitutional what we're doing. Okay. So less than a majority of the judges said, yeah, you got to have a large number of people before you can consider it public welfare. Number 3, the issue involves a matter of general importance to a large number of people rather than to individual or small groups of people. So I just got the 2 confused because I've been reading this too. I researched it. The outcome of the investigation could reasonably be expected to benefit a large number of people rather than to benefit only an individual or small group. The issue involves a matter of general importance to a large number of people rather than to it. Okay, so the distinction between the 2 here, because they sound the same, is the outcome of the investigation or the issue involves. Okay, so in either case, this has got to be a lot of people, and it can't just be onesies or twosies. So if you got public corruption and one person, one of our neighbors is being subject, and there's no resolution any other way than through a grand jury, the courts have said, so sorry, grand jury, you can't do it because you can't investigate because it's only involving a matter of a small number of people. You see the problem with this? Corruption that the grand jury should involve itself in is just big corruption. As long as it's small corruption, this is not your concern. An issue that concerns primarily a private matter rather than one that concerns the general public is not generally an issue concerning the public welfare or safety within the scope of the grand jury's investigative authority. An indictment is not a report as used in Criminal Rule 6, okay? So there's a distinction here, the last sentence, that reports are not indictments. All right. I'm in general agreement here that the concept of public welfare and safety is not supposed to be targeted to private individuals. Okay, I get that. This is where it goes into, we as citizens in the grand jury, serving on the grand jury, need to know and understand this. the definition of public welfare or safety is not retribution to your neighbor. This is where our character and our ability to know what's right needs to carry the day. Otherwise, if we don't, you're going to have a judge telling you what you can and can't do. So if you can't trust the 12 members of the jury to come up with understanding collectively of what public welfare or safety is, then you're going to have to rely upon a judge. And so why would we even have a constitution? Okay, here's where it gets good. Commentary. Okay, so this is the judge's thinking with regard to the rule that we just read. The grand jury is constitutionally authorized to investigate matters of public welfare or safety and to issue reports on the result of such investigations. Semicolon. Subsection A generally describes, and that's what we just read above, generally describes the reasonable scope. So there is unreasonable things that the judge thinks, or the court thinks that grand juries should not be subject to, should not make their attention. So it describes the reasonable scope of that authority. Adherence to subsection A will ensure that an investigative grand jury is justified and that the grand jury's use of state Alaska resources is reasonable and appropriate. Okay, so now we're going to be thinking about the money and the time that you're wasting of the administration of the court system of the Department of Law if you're investigating something that they don't want to see investigated. To be investigated, a matter must concern the public welfare or safety, for example, systemic issues. Systemic issues, or an ongoing, reoccurring issue impacting general public could be within the scope of the grand jury investigation. So a one-time incident, not the grand jury's purview. That's what the courts say. Does that mean that the grand jury through the court rules has just had their ability to investigate a one-time incident that concerns the public suspended? I would say so, because the court is going to point to 6.1 and say, grand jury, you can't investigate that. That's a one-time incident. It's not systemic. Purely private matters, such as, for example, an investigation into any individual court case of any type, whether currently open or closed. Oh, wow, that's interesting. In my mind, when it said private, I was thinking a dispute between neighbors. The court is saying this actually means the grand jury cannot do any sort of investigation into a court case as to whether justice was carried out in a court case or whether there was corruption in how somebody was convicted, for example. If there was a court case that was that the government railroaded somebody and put them in jail, would that be a matter of public welfare and safety? I think so. I think that would be a matter of public welfare and safety. Okay, what else? To be investigated, a matter must concern the public welfare or safety. An investigation into what would be an example here? An investigation into the Department of Law's decision not to prosecute a particular incident as a crime, or an investigation into a private dispute among citizens that could appropriately be the basis for a civil or other court case. Okay, this is but purely private matters such as do not rise to that level. So if an investigation into the Department of Law's decision to prosecute or not prosecute is something that the grand jury cannot second guess. The courts are literally saying the grand jury can investigate the public welfare, but not if it's going to second guess the Department of Law. So here's where we get a situation where the courts have put rules in place now in their court rules that a member of the public can come to the grand jury, and supposedly a member of the grand jury can present information to the grand jury but only if they go through the Attorney General. So right now, if you have information that you want to present to a grand jury, you have to go through the Attorney General, and the Attorney General has to bless off on whether you can present that information to the grand jury. Okay? So this is a systemic flaw in the court rule and the court's thinking here, because now if there's evidence of a crime and the district attorney and the attorney general don't want the grand jury to see it, they'll just prevent that individual from going to the grand jury. If there's corruption in the Department of Law, why would the attorney general or any of the district attorneys allow that member to present information about corruption to the grand jury? Furthermore, since the attorney general is appointed by the governor, if there's any corruption anywhere in the executive branch that would make the governor look bad, why would the attorney general allow an investigation to get started by a grand jury? Having the attorney general be a gatekeeper to make a decision as to what information can be presented to a grand jury for them not to investigate, to decide whether they want to investigate or not. We get further down into Court Rule 6.1, and it starts talking about the review of reports that the grand jury issues. Okay. And to summarize what this means is that the grand jury is going to release a report to the court, and the presiding judge is going to read over the report. And if the judge has any problems with the report, he's going to prevent it from being released. He's going to make his notes, and then he's going to send it back to the grand jury, and the grand jury would then have to decide what they want to do because the judge said you can't release it as is. So the grand jury can issue reports, thinking of the Constitution here. The grand jury can issue recommendations on the public welfare and safety only up until the judge agrees that they can be issued. Once the judge disagrees, then the grand jury can't issue a report anymore. Does that sound like a suspension to you? So grand jury can issue some reports as long as the judge agrees. That's not suspended. As soon as the judge disagrees, grand jury, sorry, you can't. Your ability to issue that report is now suspended. The educated lawyer, the judge, their opinion trumps your opinion, the 12 of you or the majority of you. So here's the thing that you really got to boil this down, okay? In the state of Alaska, let me pull this back up. In the state of Alaska, it is the grand jury, at least 12 citizens, a majority of which, so 7, get to issue an indictment. So a person can be held to answer for a crime when 7 people on the grand jury decide that law enforcement is well within their rights to go arrest this person and put them in jail, and well within the rights of the district attorney to create a case against them, an indictment, a case against them, and proceed to take them to court to prove their guilt and put them in jail for years or whatever the penalty is. Okay. That's what we trust the grand jury to do. The whole reason we have this Constitution is to communicate agreement amongst the citizens of this state of how we're going to peacefully live with each other. And if you commit a crime, you violate the law, you commit a felony, 7 individuals, 7 or more, depending on the size of the grand jury, we can look at the statute in a minute, but it could be as many as 18. The majority of that grand jury can take your liberty away because you committed a crime. But if you've conducted an investigation into something that the judge doesn't like, you can't be trusted to issue a report on that subject. You can you can be trusted to take somebody's liberty away, but you can't be trusted to decide what's of the public welfare or safety. That's what Court Rule 6.1 says. It elevates the judge and the judge's opinion in this case to be superior to the 7 individuals that are serving on the grand jury. And why? Well, because the judge is a member of the bar. The judge has an education, and a judge has many years of experience of applying the law. Somehow the judge is superior to the 7 members that serve on the jury. All political power is inherent in the people. It's not inherent in the judiciary. It's not inherent in the educated judges. It's inherent in the people. When we have judges, when we have governors, when we have unelected bureaucrats that are corrupt, you could have the district attorney charge them, but what happens when the district attorney doesn't charge them? What happens if the district attorney charges them, but then the judge, who's part of the corruption, throws the case out on a technicality? Where do you go then? You never get to know the information because it never proceeds to trial. It never goes anywhere. Within our Declaration of Rights of an individual, our individual rights, is where you find the grand jury. The power of grand juries to investigate and make recommendations concerning public welfare and safety shall never be suspended. This is the demonstration. This is the watchdog action. This is the demonstration of the people's political power with regard to a government that is corrupt, that needs to be investigated. To have a sitting judge, or a group of judges for that matter, say that somehow a grand jury has to check with them before they can investigate something is a miscarriage of justice. It's a violation of the power that the people are withholding for themselves with this ability to investigate their government. Now, in the case of the Kenai grand jury, the concept, the thing that was being investigated was judicial corruption. And that report has never been released. Okay, there's one more picture here that you need to see. I started by showing you the court rules. Here I'm going to show you the statutes. All right, let me make this a little bigger. Let me make that a little smaller because my picture's in the way. Let's do this. And now I can make it a little bigger. There we go. Okay, so you can go to the Alaska Legislature page, aka leg.gov, and you can search in the search bar AS space 12.40.010, and this is going to come up. Okay? This is this is the law. This is the statute. Okay? Qualifications and manner of drawing grand juries. Okay, so grand jurors shall have the qualifications as drawn and be drawn as are trial jurors under this other statute. We can travel over there and you can see what the qualifications are for the juries. Okay, this is beside the point. It's not what I'm trying to get at, but you can go look. Okay. By law, the legislature has said that the grand jury shall consist of not less than 12 and not more than 18. In the case of the Kenai grand jury report that was released, this was coming out of the COVID area, and this investigation into judicial corruption, the judge said, Well, we normally put 18 members on a grand jury, but we're only going to put 12 because we're afraid people are going to get sick and die with COVID. So we're going to minimize the number of people. And what ended up happening? One of the people on the jury, on the grand jury, decided they didn't want to continue. So there were only 11 members to show up for the grand jury. Well, by constitution, a grand jury can only be a minimum of 12. So now the report has been issued. The judge has got it in their pocket, in their desk drawer. There isn't 12 members of a grand jury to return this report to, and the whole system just implodes. So the bill that's before the legislature right now and amendments that I tried to offer and try to get passed in the legislature when I was there would add to this statute that says the judiciary will impanel at least 2 alternates for every grand jury so that this type of thing doesn't happen. It's the same thing that happens with a trial jury, that you have alternates in case a member is sick or family sick or something, they just can't continue, then you've got an alternate that steps in. Okay, I digress just a little bit. All right, duty, this is AS 1240-030. Duty of inquiry into crimes and general powers. The grand jury shall inquire into all crimes committed or triable within the jurisdiction of the court and present them to the court. The grand jury shall have the power to investigate and make recommendations concerning the public welfare or safety. Okay, so this is reiterating the constitutional power to investigate and make recommendations. There's no qualification here. There's not a statute that says you can do this, but it's only when the legislature agrees. You can do this, but only when the judge agrees. You can do this only when it's a large group of people. You can't do this when it's a small group of people. None of that is included in the statute, in the law. Here's interesting. Do you know this when you serve on a grand jury? By law, if an individual grand juror knows or has reason to believe that a crime has been committed that is triable by the court, the juror shall disclose it to the other jurors who shall investigate it. This has nothing to do with the information that was presented to you by the district attorney. Has nothing to do with that. There's another section of law that deals with that. This is literally saying, if you get selected for grand jury and you know that there's a felony crime, you have an obligation to disclose it to the other jurors, because nobody wants to have felony crimes go uncharged for whatever reason. Section 1240-050, holding to answer as affecting indictment or presentment. The grand jury may indict or present a person for a crime upon sufficient evidence, whether that person has been held to answer, arrested, for the crime or not. That's the power of the grand jury. You're going about your business. You committed a felony. You think you've gotten away from it or gotten away with it. Somebody saw it. They go to the grand jury. They serve on the grand jury. The DA sees it. Somebody tells the DA, whatever. However that happens, the grand jury gets to say, hey, we're going to issue an indictment on that person and go arrest them. Okay. Here's where it ties into investigations of government. Section 1240-060, access to public jails, prisons, and public records. The grand jury is entitled to access at all reasonable times to the public jails and prisons, to offices pertaining to the courts of justice in the state, and to all other public offices, and to the examination of all public records in the state. Period. The grand jury, if it wants to investigate into any of the branches, any of the departments within the executive branch for some sort of corruption or public welfare, can absolutely do it. Do we have problems in the Child Protective Services arena? Anyone? Anyone? Do we know the truth of what's happening in Child Protective Services? As a legislator, I hear a lot of horror stories. And there's somebody there, somebody that's in the office and says, somebody really needs to do something about this. The watchdog for the people in the Constitution is the grand jury. The grand jury in this instance, they're that somebody. And the thing that they can do something about is they can go into every office of the state government and they can start asking questions. And they can look at any document that they want to look at. They can subpoena anybody they want to subpoena to have them come testify in front of that grand jury. And they can dig into what you and I cannot dig into. I would argue they can dig into what the legislature fails to dig into or doesn't have the time to. The grand jury is your somebody, and the something that needs to be done, if there's a crime that's been committed, they can indict that public officer if it's a felony crime. If it's just, hey, look, the legislature really needs to know about this, or law enforcement really needs to know about this because there's other issues here. There's other things at play. There's a bigger picture. There's wrongdoing here that really needs to be addressed by other entities within the state. That's where you're making recommendations. That's where the constitutional authority of the grand jury to make recommendations fits in. Then you issue a report. And that report is not subject by constitution or by statute, subject to the courts deciding whether you can issue it or not. Let's move on. Okay. Here's where we get into the conversation of where most people think of in a grand jury. Okay. Section AS, Alaska Statute 12.40.070. Okay. Duty of the prosecuting attorney. We have prosecuting attorneys who have not read this statute. Either they have not read it or they are ignoring it. The prosecuting attorney, and there's three qualifications. There's three duties. Let's say that. It's not qualifications, it's duties. The prosecuting attorney, first duty, shall submit an indictment to the grand jury and cause the evidence in support of that indictment to be brought before the grand jury in every case when a person is arrested, to answer for a criminal charge in the court where the jury is formed. So if you're a prosecuting attorney, you already know that your duty is to take the indictment for those people that are sitting in jail and they've been arrested because they committed a felony. All of the evidence gets brought to the district attorney. The district attorney creates the indictment and brings it to the grand jury. Grand jury investigates. They review the information. Well, I have those backwards. They would review the information, and then if they choose to investigate further, they could. And then they can issue an indictment, or they can choose not to issue an indictment. They could even choose to issue a report at that matter. Okay? Second duty of the prosecuting attorney: may submit an indictment, again, to the grand jury, in any case when the prosecuting attorney has good reason to believe a crime has been committed that is triable by the court. Notice that nobody's been held to answer for a criminal charge. So no one's been arrested yet. Somebody has just brought information, evidence to the district attorney that there has been a felony crime committed. And if the attorney, quote, has good reason to believe a crime has been committed, then they drop an indictment and hand it off to the grand jury. And the grand jury then reviews the information, conducts an investigation if they want, choose to indict or not indict. Okay, that is where our judicial system is ending right now. That is our prosecuting attorneys and our judges All of the lawyers, I think everybody who gets a law degree and comes to Alaska thinks that's the extent of the duty of the prosecuting attorney. It's like number 3 doesn't even exist. I've had senior leaders in the Department of Law, that would be the division director for criminal division, John Skidmore. I have had the counsel, the lawyer that represents the court service, or courts, represents the courts, Nancy Mead. Both of them have told me the grand jury should not be allowed to direct the district attorney to issue an indictment. They shouldn't be able to investigate something and then choose to indict somebody if the district attorney wasn't involved. Number 3, again, duty of the prosecuting attorney. This is statute, this is law that the legislature has created. Shall, when required by the grand jury, prepare indictments or presentments for them and attend their sittings to advise them in relation to their duties or to examine witnesses in their presence. This is a supporting role. Shall prepare indictments or presentments for them and attend their sittings to advise them. When required by the grand jury is in charge in number 3. The grand jury is giving the direction in number 3. Go back to number 6, rule 6. Here's your oath that you take as a grand jury member. You will diligently inquire and true presentment make of all such matters as given to you for your consideration by the district attorney. Numbers 1 and 2, duties of the district attorney. That's how the court system is operating right now. Or shall otherwise come to your knowledge in connection with your present service, meaning there's some other way, there's some other thing that you've come to know about. And when required by the grand jury, the prosecuting attorney is to prepare an indictment. This section right here is what's being stymied. On 2 demonstrable cases, we have evidence. There is recording in one case and affidavit in the next case of 2 grand jurors who tried to present information to the grand jury to ask them to decide whether they want to investigate. And you've got district attorneys and John Skidmore from the director of the criminal division stepped in and said, I'm going to question you. What are you wanting to share with the grand jury? And no, you can't share that information with the grand jury. How can the grand jury do what it's supposed to do by statute and by oath if the district attorney or the judge, in one case, the judge is in agreement with the division director, John Skidmore, that he can't present information? You can't, the prosecuting attorney is ignoring the duty that they have to advise and be subordinate to the direction of the grand jury. Next section. Did you know this? When a grand jury does not return an indictment, the charge is dismissed, and it may not be again submitted to or inquired into by the grand jury unless the court so orders. You know what happened down in it's down in the Panhandle. I'm drawing a blank. It wasn't Sitka. It was. I'm talking about the court case that came up with regard to the police chief, the chief of police, Sitka. Oh man, all of those southeast towns kind of run together. I've never lived down there, except for in Juneau. Forgive me. The point that I'm trying to make here is that if the grand jury does not return an indictment, there's a statute that says that it may not be again submitted to that grand jury. And yet, in the case of this police chief down there, 3 different times the prosecuting attorney put forward an indictment for the same thing against that police chief. I'm reading this as violation of the statute. Section 1240.090, questioning juror for conduct. A grand juror cannot be questioned for anything the juror may say or any vote the juror may give while acting as a grand juror. And that's in relation to any matter legally pending before the grand jury, except for a perjury of which the juror may have been guilty in giving testimony before that jury. Okay, so if there's wrongdoing here on the juror's part, then they can be questioned. Okay? It is my opinion, and I think the evidence will support it, that our Assistant Attorney General in charge of the criminal division violated this statute when he reached down in and prevented a grand juror from bringing any information to the grand jury, sequestered them in a separate room, and questioned them about what they wanted to present to the grand jury, and then proceeded to tell that grand juror that if they presented that information, that they'd be jeopardizing themselves. They'd be putting themselves in hot water. Why do you need a grand jury to be able to investigate matters of the Department of Law or of the courts? Because corruption is not just in the convenient places. Corruption happens in the places where people exercise power. Why can we not have a constitutional form of government that relies solely upon those that are hired, elected, appointed, and hired to enforce the law? Because those very people can be the ones that end up being corrupt. And that is why you have a grand jury that is separate from those branches of government, that has the authority, the constitutional authority to go ask questions and start investigating in matters. Yesterday, I started this talk today highlighting a Senate committee hearing. The Office of Management and Budget is presenting to the Senate Finance Committee on another supplemental request from the executive branch for the budget for fiscal year 26. And in the testimony that the budget director is giving, she acknowledges that there is vacancy money that was appropriated for the hiring of personnel that has been spent on things other than hiring personnel. And now the Department of Law needs $2 million more. Furthermore, in her testimony, she highlights where there are, I just drew a blank on the R name. It's a technical word. Ratifications. I had to get that right. There were ratifications that the Office of Management Budget is going to be presenting to the legislature. You know what a ratification is? A ratification is where a department, an entity within the executive branch that's covered under the budget, spends more than what was budgeted. Do you think if we have an executive branch, something in the department, let's say it's Department of Health or Department of Child and Family Services or Department of Revenue or whatever, you pick the department. And that department is spending more money than we've given them, than the legislature has given them, than they've been appropriated for. Do you think that's a matter of public welfare or safety? I mean, what if it's in public safety, Department of Public Safety? That very clearly then could be a matter of safety. But public welfare is efficient use of our money. Public welfare? Do the people care whether their government is being efficient with the money? I hope you can see where I'm going with tying these two conversations together when discussing a grand jury. This is not just about grand juries issuing indictments for people who have committed felonies. The grand jury has the authority to step into every office in the state government and look at any public record. So if you have ratifications coming from particular departments, this is literally saying, we gave you $1 million, you spent $1 million plus. You spent $1.2 million, $1.5 million, whatever. You've spent more than $1 million. And now the government has, the executive branch has to come back to the legislature and issue this ratification so that the legislature acknowledges that they spent more money than they were given. You tell me how in a budget process, the administration can come to the legislature and say, look, we just don't have enough money. You need to give us more money. And then at the end of the year or multiple years later, when the accounting catches up, they come back to the legislature and say, oh yeah, we spent more than what you gave us. We spent more than what the law said we had available to us to spend. Where did you get that money? All of the money that goes out from the purse, from the legislature, is by law. It is appropriated by law. There is some latitude given to departments to be able to move money around. And I'm not suggesting that should be prevented, okay? That's not the point that I'm getting at. The point that I'm getting at is there is very little transparency. I would say no transparency within the legislature right now on this money that's being spent that's in excess of what they were authorized to spend. Where did the money come from? Why do we have as a process where we are appropriating money for the executive branch to hire people that they have no intention of hiring, and they just use that money as a slush fund, as their own discretionary fund to do other things with? The legislature is doing absolutely nothing to curtail that. The executive branch is doing absolutely nothing to curtail that. That is a waste of money. When I counted those dollars up, my final years in the legislature, that was $300 million that we were appropriating for positions that had nobody in them. Now, in fairness to the system, some of those positions were temporarily vacant and they were in the process of hiring. But when you compared the number of jobs that were announced on the hiring website to the vacancies, not all of the jobs were being hired for. They weren't being advertised. The vacancies have a date on them. We know how long they've been vacant, for how many years they've been vacant. So this literally is a portion of $300 million at that time that was just a discretionary fund for the departments to spend whatever they wanted to spend. The legislature's not fixing that. The governor and his team are not fixing it. They just continue the system as it is. So you tell me, if all power is politically, it comes from the people. It's inherent in the people, like the Constitution says. That means whatever the government's doing, we're the master. We elect representatives that should be dealing with this, but they're not. Well, you know who can deal with it? The grand jury can deal with it. The grand jury can just say, you know what, we're going to go investigate this, and we're going to present the information to the public, a recommendation to the public of what needs to happen. That way, at the next election, people are fully aware of who's doing what. Do you think you get the truth from your representative when you ask questions? As a representative, do I think that I get the absolute truth from the administration when I ask questions? Absolutely not. The grand jury can subpoena people, and they're going to get the truth. Because if they don't, they'll be held in contempt, and those bureaucrats will be jailed. You want to fix our government? Fix the grand jury. Allow the grand jury to do the constitutional authority that it was designed to do Go back. You can go back. If you don't trust me on this, you can go back to the convention and read what the delegates said about creating grand juries. It is very clear that they were focused on the grand jury being able to investigate its own government, the people's own government. So this is more important. This issue of the grand jury is more important than any one person or any one case. This is a key to better government, to less costly government. Yes, an investigation by a grand jury would cost money, undoubtedly. But if you've got millions, tens of millions to hundreds of millions of dollars being wasted in state government, spending a little bit of money to empower the grand jury to do some investigations is going to help a whole lot. Let it be known that a grand jury goes into one of our departments and subpoenas a bunch of records and then issues a report about the corruption that they find within that department. What do you think happens in all of the other departments? Nobody wants the grand jury coming into their area and doing an investigation because they will not be able to hide. You want to see bureaucrats start taking management serious? There needs to be some sort of teeth to making bad management decisions. I'm not advocating that all of our managers need to be fired. But if you're mismanaging your department, you probably need to go work somewhere else. How am I going to know that as a legislator? The process that we have in our government right now does not allow me to get to the details of of where that mismanagement or dysfunction is. I get to scratch at the surface and that's it. The grand jury, they can get into the details. You don't need to be an expert. What training did I have in finance before I went and served on a finance committee? Before I dug into and learning about grand juries. I didn't have any training of this. I was a high school graduate, and I graduated from college with a integrated studies degree. I had emphasis in telecommunications, computer science, and political science. I'm not an expert at this, but I can read and I can decipher and I can understand. I can be curious. So can you. So can 12 members on a grand jury. They don't need to be trained attorneys. They don't need to be trained economists to understand this stuff. They just need to be curious and they need to ask questions until they get answers that they're satisfied with. When you hear somebody say, somebody ought to do something about this. If it's regarding government corruption, then that somebody is your grand jury and that something is issuing a report so we know what the facts are. Okay, I'm taking a breath. I'm going to check in with you all. I had to get this off my chest today. Lisa says, good evening, Ben. Heard you call in. Great points you made. You must have been talking about the committee meeting that I provided testimony. Thank you for your feedback. Craig says, I enjoy mocking our legislators. You enjoy it. Well, Craig, you might be one day. Lisa served on a grand jury. Someday you should share your experiences. So some malfeasance is acceptable. Is that in relation to the Juneau Clown Posse? I think that you could say that malfeasance is the nature, like waste is the nature of bureaucracy because it's other people's money. But malfeasance or actively working against people or things, I don't think that's acceptable in any way. I mean, yes, we know that it happens, but it's not acceptable and it should be rooted out. So much of what's happening that I see of administration and the waste of money is because nobody fears anything. They don't fear the consequences of wasting money. There's no fear. No fear. These court rules are wrong in many ways. I agree. I think court rule 6.1 needs to be abolished. I think the jury can be trusted to decide what is of public welfare and issue a report. And we don't need to have a judge second guess the grand jury's ability to make that decision. Brian says, thou shalt not question the wisdom of our betters. Yeah, I mean, that's literally what's happening. So Christopher says the court system is corrupt. The DA only wants wins, not justice. Possibly. I think about what happened down in Ketchikan is where that Ketchikan City police chief issue. I don't think justice was served by running him out of town. I don't think they were just trying to win. I think somebody had an agenda somewhere. And as far as I'm concerned, that whole debacle, and we're not going to get into it tonight, but that whole debacle is ripe for a investigating grand jury to go figure out what happened down in Ketchikan. And it's not just in Ketchikan, it's somewhere in the Department of Law. That the details that have been presented with me, that smells of corruption 100%. Okay, Christopher, you're talking about the 4 boys in Fairbanks just from the Hartman case. I am not familiar with that. Don't be surprised because I'm down here in the Kenai. Brian, are you referring to Christopher? Put them in jail or exonerate them? I don't. I got to try to keep up with your comments as I'm talking because trying to go back and figure out what you guys are talking about was is not working. I gotta slow down a little bit. Let's see. Sherry says, I just can't fathom how it got to the point that the foxes are guarding the hen house. Okay, Sherry, really good point because that's kind of what's happening. How it happened is because you and I didn't know any better. We've allowed it. The judges that we're having problems with here, there is a remedy. There are 2 remedies for that. We have a retention vote on judges periodically. We don't get to elect them, but we, the people, get to fire them. Who are the judges that were involved in setting up the system that's the fox guarding the hen house? Who are the judges that put 6.1 in place, Rule 6.1 in place? The Supreme Court judges. Okay? If Alaskans would start exercising their right to not retain judges, a message would be sent to the judges that they need to take that into consideration if they want to continue judging. Okay. Second way that we can deal with this is through the legislature. The Senate has the ability to impeach judges. They just draw up a resolution or a bill that impeaches the judge. I'm not sure which one it is. I've never seen it happen. So the Senate could impeach the judge. Just let one judge get impeached and see what happens within the judicial branch, within the lawyer circles. This is the accountability piece that's missing And we, the people, are the ones that are responsible for that. Until I came into the legislature and until I was presented with this issue with the grand jury, I didn't know what a grand jury was. I had my theories, or my, just based on my education, my high school education and college education. I didn't know exactly what the grand jury was. I certainly hadn't read the statutes. I didn't know anything about the grand jury. I kept my nose clean. I didn't have to go to court. District attorney, I don't know. I wouldn't even be able to know him if I walked past him in the street. We have to take responsibility for this. And it doesn't, the system that we have doesn't work if we, the people, don't know that this is our power, that this is the responsibility that we have. You want to change what's happening in the courts? Then you operate through the legislature and you change the court rules. The legislature can do that. You want to put statutes in place that then the courts have to address their court rules, because the court rule can't override the statute. It works the other way around. You put the statute in place, the courts are going to have to change their court rules to fall in line with the statute. There's just too many Alaskans that don't know how government works or care. And I would say it was too many conservative people don't know and don't care. That's the root of the problem. So this is Oversight Live. I think we can change that by providing oversight, by sharing this message. Now you've got an opportunity. This is a pretty good breakdown, I would think, of at least Ben's opinions of the grand jury situation. There's probably some more details that we could parse out here, but for the most part, this is a pretty good synopsis. So now we just have to share it. We just have to get the information out into the world so that people who are going to go serve on a grand jury, well, they've seen this information. They know what questions to ask. When the district attorney says, "Oh, well, you can't ask that question, or you can't present that information to the rest of the jury," you can say, "Why don't you show me that in the statute? Show me where I cannot address the grand jury for an issue that I have evidence of a crime. Tell me that. Show me where you get your authority. Stand up to the district attorney. They're not going to put you in jail. They're not going to put you in jail. District attorney's shaking in her boots if a grand jury member stands up and challenges her authority. She didn't know how to deal with that. Lisa, that may be true, but it's only because there is only one person speaking. When more people are speaking, saying the same thing, then it gets harder to ignore. And it doesn't take a majority, it just takes a minority. A loud enough minority can get the attention of the majority. And if there's one area, if there's one thing that you could empower as a minority to get the attention of the majority, it would be the grand jury. Because the grand jury doesn't have power to do a whole lot of anything, okay? What it can do is investigate, and what it can do is present information to the public. But it doesn't control the police force. It can't go arrest people on its own. It can tell the district attorney to indict somebody and go arrest somebody, but if the district attorney chooses not to, grand jury has no power to force them to do it. There's no authority there. It's a watchdog. All the grand jury can do is investigate and present information and indict if it needs to. And think of that as being presenting information to the judge and to the court, right? We investigated, the information was brought to us, we indicted. Indict is the special word for we're presenting information to the court. So now the prosecutor and the defense and the defendant all have to get together and figure out, and the jury gets to figure out whether that person's guilty or not. Okay? Grand jury just presented the information. and just said, yeah, we think that there's enough information here to charge him. Send it to the court. But the grand jury doesn't have power. It can't make changes. Like, it can't force the legislature to change the law. It can't force the courts to change their court rules. But what it can do is investigate and issue reports and refuse to be silenced by any of the branches of government. That's what it can do. The members of the grand jury, the 11 out of the 12 members of the grand jury that has the report, they should be furious. And maybe it's not all 11, maybe it's just a majority, because that's all it takes. They should be furious that they went through months of work and that report has not been released. Those people should come together somewhere. They should go to, contact each other and go to dinner somewhere and figure out a plan of how they push back against the courts. They were a grand jury. They were a group of people who issued a report that was never released. Those individuals should be pissed off. Their authority was just squashed by the courts. You don't have any control, but you do have the ability to get loud. That's what the authority, that's how the government changes. That's how people start doing better things, because you're highlighting it, right? In the military, we said, inspect what you expect. People are going to naturally get lazy. You inspect things, you inspect 18-year-old soldiers because they're going to get lazy. You inspect them and you inspect what you expect of them so that they know you're coming. They know you may come. You don't tell them when you're going to do the inspection. They'll be on their best behavior. You do a surprise inspection to find out what's actually happening. What's the surprise inspection in our state government? Nothing. There's no fear in our government of anybody turning over leaves or inspecting something to make sure that everybody's doing what they're supposed to be doing. There's no fear of it. The legislature's not doing it. No. This whole Senate meeting where you've got OMB telling them that the statute they passed appropriating money didn't work and we spent more money, and we've got this discretionary fund of money that we've already spent and we need more. That is that is the executive branch playing the fool of the legislature. Yeah, you passed this. You passed the law. You passed the budget. Didn't really mean anything. We went ahead and did what we wanted to anyway. And now, can you give us more money? There's no fear. There's no expectation of consequence that's being demonstrated by our managers in state government. None. Sherry says that she sat on a grand jury many years ago. One of the jurors informed us that the grand jury has the power to change the charges. That is partially correct. I was absolutely stunned. I had no idea that we were able to do that. Yeah. So here's, I'll show you how. Okay. I'll show you how. So you can take this to the next conversation when somebody does this. This is how it works. All right. Here we are looking at the statutes. This is how you change the charges. Let's say, for this example, that the person wasn't arrested. Okay. So this prosecuting attorney came to the grand jury with an indictment because they believed somebody had committed a crime, right? Attorney has good reason to believe a crime has been committed and is tried by the court. So that's what the district attorney did. They brought the indictment to the grand jury, and the grand jury asked for information. They subpoenaed people. They did their own investigation. They said, you know what, district attorney, we don't agree with you. We don't think that this person needs to be charged with a felony. But you know what? In our investigation, we do realize that this person over here, they're actually responsible for this. And so we think they need to be charged with this particular crime. Oh, by the way, district attorney, what's the crime called when X, Y, and Z happens? And the district attorney tells them, because why would the district attorney do that? Because here's the duty of the district attorney. Shall, when required by the grand jury, attend their sittings, their meetings, and advise them in relation to their duties or to examine witnesses in their presence. So when the grand jury says, we think this other person over here is guilty of something, what is it called when they do this? And does that violate the law? And what's that called? And the attorney comes back and says, oh yeah, here's the technical name for it. And oh yeah, that's indictable. Okay. By law, the grand jury now tells the district attorney, when required by the grand jury, prepare indictment, buddy. Whatever you gave us, we're saying no to, because that's the authority of the grand jury. We say yes or we say no to indictments. So the indictment you gave us, we say no to. Change the indictment to what we think it needs to be. That's exactly what the grand jury can do. By law, it's right there. If you're a sitting grand jury member and the district attorney or the judge is not giving you the statute that is empowering you and requiring the district attorney to attend to you, there's something wrong with our system. If you're a grand jury member and you don't know that this is the power that you have when you go sit on a grand jury, this is the law that's backing you up, then you're wrong. You're part of the problem. Why go sit on a grand jury and serve the people and not know what your authority is? Is the district attorney going to like you or like this process? Heck no. The district attorney is going to be tongue-tied. They're not going to know what to say. They'll probably say something wrong and disband the grand jury. That's probably what they'll do, because that's been done before. If the district attorney has if the grand jury has a problem with the district attorney, then the message goes to the attorney general from that grand jury, and the grand jury, or to the judge, and the district attorney or the grand jury says, hey, we need an independent prosecutor. We do not think that justice can be carried out with the district attorney that is assigned to us. We need an independent prosecutor. And now let the judge and the attorney general figure it out. With regard to what's happened in the Kenai grand jury, an independent prosecutor was assigned to the grand jury. So that's what you do. If you've got a problem with the district attorney, you just, as the foreman and the group, the district, the grand jury, majority of you, you just say, hey, out of the room, district attorney, we need to talk. Get out. Y'all talk about it. You come up with your plan. We don't need this district attorney anymore. We need an independent prosecutor. And now we're on hold until the judge and the Department of Law figure out how to get us an independent prosecutor. And no one else needs to know what's going on. The grand jury is secret. You've taken an oath to keep that secret. The statute backs you up. Let me find my mouse here. I thought that I had read something here about the maintaining secrecy. Maybe that was in the oath of office that I read. Okay. Yeah. So I'm sorry. I must have been thinking about the oath of office. Because you're promising in the oath of office to maintain secrecy. Because it's not here in the statute. Anyway, this is the thing that you should, this particular statute here, 090, as a grand juror, nobody gets to question you. Unless you've done something wrong, nobody gets to question you. Nobody. District attorney wants more information. If it's not about what they gave you, district attorney, I'm not talking to you. You can't question me for this information. Judge, I'm sorry. We have something that we need to discuss, and district attorney, you're not part of this right now. We'll let you know when we need your advice. You cannot be questioned. Anything that's legally before the grand jury, that is not just what the district attorney gives you. That is information that you may have unrelated to the district attorney. Now, I will caveat and I will say that the district attorney has a lot of cases. So when the district attorney brings a case to the grand jury, the attention of the grand jury needs to be on the district attorney's case. You can't be working on two cases at the same time. So there is a time and a place for the grand jury to exercise its authority. When that case is done, or before you start the next case, the conversation with the district attorney sounds something like this. We have matters that we need some time to discuss before you bring us another case. So please let us know. Please calendar some time for us to be able to meet without one of your cases. And that's what that sounds like. And they're obligated because you have something that you need to discuss. That's your authority as the grand jury. You're impaneled. Your responsibility is to meet and discuss the matters of the state. You're not at the beck and call of the district attorney or the judge. Now they have authority and they have roles to play. But you as a member and the grand jury as the whole, your authority is there as well. And you're supposed to be there to investigate and to report. Okay, I'm catching up on the comments here. Christopher says the problem with the grand jury only hears the DA side of the criminal complaint, not the other side, to understand what really happened. Well, if the grand jury doesn't ask questions and just relies upon that evidence, then you're absolutely right. That would be the only thing that's being presented to the grand jury. Do you also know that the requirement of the prosecuting attorney by their bar membership, they are supposed to bring exculpatory information to the grand jury with the information that they're bringing to have the indictment. If during the grand jury's investigation, the grand jury comes to find out that the district attorney had information that would have exonerated or prevented the grand jury from agreeing with the indictment, but they didn't bring that information to the grand jury, that is a crime. That is malpractice by that attorney. I'm not sure whether it's a crime in the legal sense. That is malpractice by that attorney. The district attorney has an obligation to bring exculpatory evidence. Exculpatory means evidence that would exonerate or prove that somebody didn't do something. Okay? They have the obligation to bring that to the grand jury so that the grand jury can make an informed decision. If they're not bringing that, we need a different district attorney. The grand jury should not just assume and trust the district attorney is presenting all of the information that's out there. working for the district attorney. You're not partners in this. We go back to the constant. Let me just bring up this Constitution again to make sure that I really nail this point. This section of the Constitution is our declared rights, inherent rights, source of government, our civil rights, our individual rights for freedom of speech, freedom of religion, freedom of assembly, due process, grand jury. This is spelling out our individual rights. We have the right to not have the government charging us without our peers telling us, yeah, they got a case against you. 12 of, at least the majority of the 12 say, yep, they got a case against you. You're going to get arrested. Your role as the grand jury is supposed to be in defense of your people, defense of the victims, and defense of people who could be erroneously charged. It's a huge responsibility. You are not serving the district attorney. You are not serving the judge. You're not there to convict people or to just indict people with whatever information comes to you. You're supposed to figure out whether this is the right thing to do or not. If the evidence doesn't make sense or you want more information, then you ask the district attorney for more information. You can demand that people come to you, subpoena people to come before the grand jury and testify to the grand jury. Tell me the truth on this matter. We want more information. We're not sure that the district attorney has a great case. We're not sure whether this person should be indicted and be charged with a felony and go through this entire process. We're skeptical. Why are we skeptical? Because if we were in the same shoes as somebody was railroading us, we would want our peers to have our back. Just like the victims of crime would want you to have their back in indicting somebody that's actually committed the crime. This concept of the grand jury came to a conclusion because that's what the prosecuting attorney gave them the information. I'm sorry, but that's abdication of responsibility of the grand jury. The members of the grand jury did not know their authority. You do not have to take what the district attorney says as the gospel. You can investigate it and poke holes in it. That's why we have a grand jury, partially, to protect ourselves. And it's protect ourselves from a runaway runaway district attorney who has political aspirations, and the more people he can get indicted, whether they're guilty or not, is going to get him elected sometime or get him that next job. He wants to get hired at that next law firm. Whatever. You got to protect the public from that kind of corrupt behavior, just as much as you have to protect the public from the guilty who are committing crimes out there. That's your purpose, to find out what the truth is and then issue an indictment or issue a report and let the public know what the truth is. You're the watchdog. Lisa, interesting. You say that in the months of grand jury, we handed down 2 indictments and 2 investigations. I'm curious what years those were, Lisa, and was that in the state of Alaska? You said that 2 investigations. Did that result in reports, or what was the result of the investigations? See, Lisa said they heard both sides. Yeah. I mean, it's a possibility you got that Christopher's on or is speaking about a grand jury that doesn't know what their authority is, and they don't ask questions. They just rubber stamp what the DA brings them, right? Hey, good conversation, Christopher and Lisa. That's why we're doing this. Okay. Yeah. Sometimes service on the grand jury is not pleasant. Lisa says that they even had to look at photos that made individuals sick. Some of that was hard. Yeah. Human beings do heinous things, and if it comes to a grand jury, you're gonna be presented with that information. So you got to have intestinal fortitude. Oh, Lisa, thanks for clarifying. No, it was in New York. Yeah. I am unaware, and I haven't done an exhaustive search, so let's just be clear, but I'm unaware of any grand jury investigations that issued reports since the Sheffield case in the 80s. I'm unaware. Maybe it's happened. I have not seen that information. I think that the investigative grand jury was shut down after the Sheffield administration with that court rule change at 6.1 when it was implemented. As soon as you put the judge in charge of deciding what information gets presented from a report, then how would you know? The investigation that the grand jury was doing was secret. How would you know? If it didn't result in an indictment, you would never know. There's a report generated. The judge said, no, we're not we're not going to release that. And you'd never know unless the grand jury got vocal with it when they're no longer a grand jury. Or even if they were a grand jury, they went to the public and said, hey, look what's happening. You would never know because it's secret. But to the best of my knowledge, there hasn't been public reports released by a grand jury. Maybe I'm wrong, and I would eat crow on that. I do know that for this particular conversation, the report that was not released that's fact. That's for sure, for certain. There is a report that was generated that was not released, and the judge is the reason why it wasn't released. Oh, Lisa, that must have been an interesting investigation to be looking for a grand jury to be looking in on police conduct. Yeah, I mean, this is a real thing. People who think that the grand jury's purpose is just to prosecute criminals are woefully uninformed. The grand jury's, dare I say, primary responsibility. I don't know if primary is the right word, but you look at the statutes that give authority for investigations, and you look at the purpose of, or the duties of the prosecuting attorney. They're supposed to attend to the grand jury, and when directed by the grand jury, issue indictments. It's very clear that the grand jury is supposed to be doing investigations and either indicting or presenting information. That's their purpose. Directed right at the government. I'm of the opinion that we really don't want our grand jury exercising investigatory authority on matters of individuals, of private citizens. I really don't want that focus of our grand jury. I do want the grand jury focused on the government, and that is public welfare. What's happening on my private land? None of your business. It's not public welfare. That's private welfare. What's happening in our government is public welfare. You got plenty to be worried about out there. You don't need to be worried about what's happening on my land. I'm not doing anything wrong anyway, but I'm just pointing out that we don't want a grand jury. We don't want, the power was never intended for public welfare to mean go after private citizens. It was never meant that way. Anyway, I trust that 12 members of the jury, grand jury, are going to be able to figure that out. I trust that that's the case. Okay. All right, folks, we're at 2 hours. Now, how time flies. We're going to call it an evening. Thank you for participating. It's been a great discussion. Appreciate all of you for joining us. Again, share this show. I'm gonna create some shorts and pull out some of the more pertinent parts here. Share those as well. It's important for people to understand that the grand jury is not just a tool of the government. It is our tool to watch over our government, to protect ourselves That's the tool. If we don't know how to use it, then shame on us. It's us. We're to blame. So let's fix that. All right. I hope you have a wonderful rest of your evening, and we'll see you tomorrow night.